It is essential to note that under section 115 of the Code of Civil Procedure, the supervisory jurisdiction of High Court in a civil revision petition is purely discretionary and rather limited. Full stop. However, this court has held on many occasions that such discretion must be exercised in a lawful and valid manner on the basis of well entrenched principles of the exercise of such discretion. Full stop. Therefore, the High Court shall not arbitrarily refuse to exercise its discretionary powers, rather it must satisfy itself as to whether jurisdiction has been exercised properly and whether the proceedings of the subordinate court suffer from any illegality or irregularity. Full stop. We note that this argument was not made by the respondent at any stage of the case, either before the civil judge, the additional district judge, or before the High Court. Full stop. Since the respondent failed to do and also failed to implead the alleged similarly placed candidates, it is not possible for us at this point to ascertain whether the respondent was discriminated against. Full stop. The latter shall not be given preference merely by virtue of the diploma. Full stop. Accordingly, the respondent cannot be given preference over the candidates appointed against the respective posts when his overall marks were significantly lower than those who were appointed on merit. Full stop. Therefore, we do not find this argument to be sustainable. Full stop. In the light of what has been discussed above, we find that none of the grounds on the basis of which the appellant was ordered to appoint the respondent against the post of primary school teacher are maintainable. Full stop.